President Obama's healthcare law is once again headed to the country's highest court, this time over its contraceptive mandate. That, of course, is the provision that requires most employers to provide group health plans that offer low or no-cost birth control. Churches and many other religious organizations are already exempt from the requirement, but the Supreme Court will decide whether for-profit corporations should be too. So far, about 40 different companies have sued on religious grounds. But it's the case brought by the craft store chain Hobby Lobby that's gotten the most attention, and it's one of the two cases the court decided to hear. The owners argue providing insurance coverage for 2 types of morning after pills and 2 types of IUDs essentially make them complicit in performing abortions, therefore violating their religious beliefs. Hobby Lobby would have to pay about $1.3 million in fines every day for failing to provide coverage. A lower court has already ruled in favor of the craft store, but the Obama administration appealed. Both sides see the Religious Freedom Restoration Act of 1993 differently. It's the federal law that says government shall not substantially burden a person's exercise of religion. Hobby Lobby argues that should apply to for-profit secular companies, not just individuals. But the Obama administration says the law doesn't extend to companies and has long argued providing contraception is necessary to ensure public health.
We decided to follow the judgment of the nation's leading medical experts and make sure that free preventive care includes access to free contraceptive care.
SCOTUS Blog's Tom Goldstein boils down what's at stake, telling NBC it's a question that's been open for a long time. Do companies, not just people and churches, have religious freedom? Legal analysts say the long-term impact of that decision, whatever it may be, could be huge. A spokesperson for the ACLU told Politico, ruling against the administration is in essence saying that these corporations can impose their religious beliefs on their employees, meaning employers could deny services entitled under the Affordable Care Act, like mental health services, blood transfusions, and cancer treatments. And a contributor for MSNBC writes, corporations could be allowed to opt out not only of health coverage for religiously contested services, including vaccinations or blood transfusions, but labor regulations. A Catholic university in Pittsburgh has already claimed it doesn't have to allow students to form unions because of its religious affiliation. Arguments in the case will likely take place in March, with a decision sometime in June. For Newsy, I'm Elizabeth Hagedorn. Multiple sources, a broader view.